Hi, future lawyers. Today, we're diving deep into the complexities of international law, the body of rules that govern the interactions between sovereign states and other international entities. So grab your notebooks because this is going to be an informative journey. All right, let's start with the basics. International law can be broadly divided into three main categories: laws of peace, laws of war, and laws of neutrality. Laws of peace govern the normal relations between states, while laws of war, also known as international humanitarian law, IHL, come into play when conflicts arise between warring states. For example, Russia and Ukraine shall observe the laws of war in their armed conflict. Civilians should not be targeted. On the other hand, laws of neutrality govern the relationship between states and those involved in conflicts. But what is the difference between municipal law and international law? It lies in their scope and application. Municipal law, or domestic law, is enacted by a country's legislature and applies within its territory. Example, the 1987 Philippine Constitution. International law, on the other hand, governs the relationships between sovereign states and other international entities. What are the sources of international law? The primary sources of international law include 1. Treaties and conventions. These are formal agreements between states that must be written, concluded by states, and governed by international law. 2. Customs. These are practices that have been consistently followed by states and accepted as legally binding. 3. General principles of law. These are principles recognized by a majority of national legal systems, such as the principle of good faith. Secondary sources include judicial decisions and scholarly writings. What is the doctrine of incorporation? The doctrine of incorporation, which the Philippines follow, states that international law forms part of the law of the land without the need for specific legislation. When are treaties binding? Treaties, to be binding, must be in writing, concluded by states, and governed by international law. In the Philippines, for treaties and international agreements to be binding, it shall be ratified by the Senate by 2/3 vote. But what happens if a state wants to withdraw from a treaty? Well, it's not as simple as sending a letter of resignation. Withdrawal from a treaty often requires careful consideration of legal and diplomatic implications. What are the grounds for termination of treaties? There are several grounds for the termination of treaties, including breach of treaty, unforeseen changes in circumstances, and error of fact. However, the principle of pacta sunt servanda remains a cornerstone of international law. What is pacta sunt servanda? This principle states that every treaty in force is binding upon the parties to it and must be performed by them in good faith. Now let's talk about state responsibility. When a state breaches an international obligation, it incurs certain legal consequences, including the obligation to cease the wrongful conduct and provide reparation for any damage caused. This principle ensures accountability in the international arena and helps maintain order and stability among states. But what about individuals who commit crimes under international law? That's where institutions like the International Criminal Court, ICC, come into play. The ICC has jurisdiction over individuals who commit genocide, crimes against humanity, war crimes, and crimes of aggression. The International Court of Justice, ICJ. Meanwhile, the International Court of Justice serves as the principal judicial organ of the United Nations and hears legal disputes between states. Its decisions help clarify and interpret international law, ensuring consistency and fairness in its application. Now let's delve into a real-world application of international law. The maritime dispute between the Philippines and China. The West Philippine Sea is a critical and strategic body of water, rich in resources and a significant route for international trade. The Philippines and China have overlapping claims in this region. China's claim? China asserts its claim through the so-called Nine-Dash Line, which includes the West Philippine Sea. China argues that it has historic rights to these waters. The Philippines' position? The Philippines contests this claim based on the United Nations Convention on the Law of the Sea, UNCLOS. According to UNCLOS, the Exclusive Economic Zone, EEZ, extends up to 200 nautical miles from the baseline, where the state has the rights to explore and exploit marine resources, establish and use artificial islands, and install structures. Arbitration case? In 2013, the Philippines brought the case to the Permanent Court of Arbitration, PCA, arguing that China's claims are excessive and infringe upon the Philippines' EEZ. PCA's ruling? In 2016, the PCA ruled in favor of the Philippines, stating that China's 9-line has no legal basis under international law. It also affirmed that certain areas claimed by China fall within the Philippines' EEZ. China rejected the ruling, stating that it does not recognize the tribunal's jurisdiction. This case highlights critical areas of international law. 1. The role of international courts in dispute resolution. 2. The principle of state sovereignty and its limitations. 3. The enforcement challenges in international law, particularly when a powerful state rejects the ruling. And there you have it. A whirlwind tour of international law, from treaties and conventions to state responsibility and international courts. Remember, understanding international law is essential for fostering peace, cooperation, and justice in our interconnected world. So keep exploring, keep learning, and until next time, stay curious.